Great. Okay. Who we elect to the Ohio Supreme Court this year could not be more important. We know that the next court, for example, will decide the meaning of Ohio's new reproductive rights amendment, and it could also decide what constitutes fair and legal districts. Recently, the Ohio Supreme Court made national news, but not in a good way. You might have heard about the infamous boneless wings case. Let me just admit a few more people and we'll continue. Okay, we've got lots of people here today. Justice Donnelly explained in his dissent, the issue is whether Berkemer, who swallowed a bone while eating a boneless chicken wing, should be able to present a jury his negligence claim against those who supplied or who prepared or served the wing, or whether a judge may decide as a matter of law that Berkemer cannot under any circumstances establish the defendant's negligence. Countering the majority opinion that boneless wing merely refers to a cooking style, Justice Donnelly wrote, "There is, of course, no authority for this assertion, because no sensible person has ever written such a thing." Justice Joe Dieters, who decided to challenge Justice Melody Stewart rather than to run in his current appointed seat on the bench, wrote the majority opinions. Because of that opinion, the plaintiff, Mr. Berkemer, will not be allowed to have a jury hear his case. Apparently, Mr. Berkemer is guilty of having presumed that boneless means boneless. To view Stephen Colbert's take on this decision, check the chat. Wouldn't most Ohioans rather have a Supreme Court that's known for decisions reflecting a good understanding of the rule of law and Ohio's Constitution? I think it's fair to say that all those on this call today would. To that end, we support Justice Donnelly.
I don't know, right there.
Are you there? Excuse me? I'm not sure what that is.
Greg needs to mute.
Okay, please mute if you haven't already. Okay. I think it's fair to say that all those on the call today would. To that end, we support Justice Donnelly, Justice Stewart, and Judge Forbes for election to the Ohio Supreme Court. So, how can we best communicate with voters, including those who are undecided, why they should vote for all these three candidates? We'll start with Justice Donnelly. What do you see, Justice Donnelly, as the best way to tell all voters why they should vote for you?
Well, first, let me say it's an honor to be here, and thank you very much for inviting all three of us to participate. I know this organization has been very supportive of us on social media, and we really appreciate that. I think in your opening remarks, you hit the nail on the head. We are going to be deciding some very important cases as we move along next year. And the case that you mentioned is instructive on why the cases we will be deciding is important. I knew that case was going to go viral. I didn't think it would go as viral as it did internationally, but I thought it would go viral in Ohio. But it continues to be talked about throughout the country for good reason. As appellate court judges, we are given Supreme Court judges, we are given immense power to assign meaning to the words in our statutes and our laws. And that case is very instructive on what they will do. What they will do, I predict, if given the chance to have power over reviewing the reproductive rights amendment. And I've seen it happen before during the redistricting cases. Fortunately, we had Chief Justice Maureen O'Connor deciding the unconstitutional maps on our side. But if you go back and look at the dissents, they say very similarly to what they said, a boneless doesn't really necessarily mean boneless. They said that with regards to the constitutional amendment that was passed by a majority of Republicans, Democrats, and independents in the state, that, you know, they sympathize with you, but you wrote it wrong. And that's what they will do with reproductive rights, I predict. I fought for that chicken bone case to get in. The only justices who originally voted for it were Justice Stewart and Justice Brunner. And unfortunately, Justice Fisher voted for it. But there was a lot of pushback. And fortunately, Justice Fisher stood his ground and allowed that case to be reviewed, because it was a case that involved, as you mentioned, a gentleman who ate a boneless chicken wing that he was advertised as boneless, and the next day he was in surgery with a 1.5-inch chicken bone perforating his esophagus. He filed a lawsuit against the restaurant, the supplier, and the manufacturer. And the trial court, which was upheld by the appellate court, threw that out as a matter of law. And the only way you can do that is if you reach the conclusion that no reasonable person could ever differ as to whether you should expect to find a bone in a boneless chicken wing. And the four Republican justices did that. And this is indicative of what they do. They've made in Supreme Court races, time immemorial, they have used this mantra of judges shouldn't legislate from the bench. Judges shouldn't be activists, which I totally agree with. When I go in front of groups of Democrats, I say, hey, I'm very grateful for your support. I'm very grateful for your endorsement. But I'm also equally grateful for the fact that you understand that when you place a judge on the bench, I don't have an allegiance to the Democratic Party, or any party for that matter. What the public wants from their judicial system is fairness, transparency, and efficiency, and judges who follow the law. Unlike in the legislature or in the executive branch of government, in the judicial system, when you take a position as to how the law applies to the facts in any given case, you have to show your work. And when I joined the bench after being a trial court judge for 14 years, I told my clerks on day one, if we're all biased as human beings, we all would like to see certain results, but the law is the law. And I never want to be accused of result-oriented analysis. What you saw in the chicken bone case was result-oriented analysis. They were trying to restrict someone's right to go before a jury trial, your right to a jury trial, and to argue that your injury was caused by one of those parties' negligence, and he was denied that right. This is how they restrict their rights. They legislate from the bench, and they will do that. And that's why it's important to vote for independent justices who believe in the rule of law. If there's a case where I believe that the law is unfair or unjust, I will say so in a concurring opinion. I will say that the legislature ought to change this. I don't like the result, and I can give you plenty of examples of that, but I follow the law, and I don't think they could say otherwise. And that's why this decision on the chicken bone has become the most ridiculed decision in the state's history. And it embarrasses judges, good, hardworking judges, both Democrat and Republican judges throughout the state are humiliated by the laughingstock that the majority created by this legislation from the bench. And this is why these races are just as important as Sherrod Brown's race for the Senate for all Ohioans.
Thank you. That really hones in on the basic issue. I wonder if there is a different kind of response, Justice Stewart, that you might have, or would you like to expand on what Justice Donnelly had said?
I think, thank you too. First, let me thank everyone for participating in this and having us here. Now, I think, Mike hit the nail on the head. I don't want to be redundant in what he's already said, but, as a basic matter, if the law is on your side, you should win. And, when understanding, for those who are not lawyers in the group, understanding that this case, the boneless chicken wing case, is a case where the victim, the person who suffered injury, this wasn't someone who happened into a restaurant and ordered boneless wings and paid more for them and got a bone and was mad and said, hey, there's a bone in my wing. I mean, life-threatening injuries here. And as bad as his injuries were, legally, he may not have won if he couldn't prove negligence. But he was never even given the opportunity to do that. The judges in this case, from the trial court to the appellate court to the majority on our court, shut the door on it. It's by saying, as a matter of law, no reasonable person would think that the word boneless meant without bones. When it's almost like saying no reasonable person would think that 12 o'clock high noon in Ohio meant that it was daytime. It meant you just kind of wrap your head around it. Now, I know some people think that was created out of whole cloth, and it is. And in all fairness to the majority, in this particular case, there was a menu that had wings, a side that said wings, and a side that says boneless wings. And the boneless wings cost more, right? The production is different from it. And they did that foreign natural test. Like if he had found a nail in his wings, that's foreign, that shouldn't be there. If you found a pencil in your wings, that it shouldn't be there. If you found a paper clip, it shouldn't be there. Those are foreign objects, right? For them, that's clear, and I think that's clear to all of us. But by saying, but bones are natural to chicken, so you shouldn't be surprised when some are there. You should warn against them. If the meal were chicken cacciatore, chicken tetrazzini, just a plain chicken meal where you would normally not expect bones, but there was a bone there, maybe that analysis holds up. But when you specifically advertise that you have removed a substance from your meal, and in this case, they specifically advertise that they had removed the bones from this meal, then that foreign natural test doesn't apply here, because bones should no longer be natural when you have said you have removed them. And so that becomes then, can your average consumer, can your average diner rely on what's being said in the menu? And this could have been avoided too. And hopefully this case will, for restaurants and for people across Ohio, if not across the nation, will say, the restaurant can say, we make every effort to remove the bones here. However, there's a situation where some might get through. At least it places the consumer on warning. But what it said to me, that opinion, quite frankly, was your average jurists who've been lawyers for a long time, hearing cases, promote a business class, doesn't want to see people recover. That average person wouldn't think boneless meant boneless. But that's not the average consumer. That's not the average diner. Everybody doesn't have a law degree. Everybody hasn't sat on a court. Everybody hasn't read the law about foreign and natural objects in a case. And so that's where so much of a majority is out of touch. One of the things that is near and dear to me in being a public servant in our judiciary is not losing sight of common sense. And for those, who are familiar with my background, after I was an appellate court judge, I went back and got a PhD in social science. And that degree helps me to ask the right questions. And it helps me to think about potential unintended consequences of our decision-making, which we have to do. So we can't make decisions in a vacuum. Yes, we are to apply the law and we are to be guided by the law, but those decisions can't be made in a vacuum. And so, that's one of the stark differences in me and my opponent in this race, who, as you mentioned earlier, has never comes to the court with no prior judicial experience, never having run for election for a judicial seat, never aspired to be a judicial candidate ever, and who has been handed a seat on our highest court for, I don't think you can tell for any other reason but for political reasons. And that's not who we want in our judiciary. There is no independent jurist in that 7th seat. And I think that's a travesty and an insult to the citizens of the state of Ohio.
Thank you very much. Obviously, you all talked about this case a good bit, and it's an important one, as you were saying, that it points out a lot of key differences between the current majority on the court and the minority, which we hope will be flipped. Judge Forbes, what would you like to add to that, and why should voters, including undecided voters, vote for you?
Thanks so much, Debbie, and thanks to everyone for being here this afternoon. We really appreciate it because the only way we can win, of course, is if we get our message out, not only to the 39 of you on today's call, or I guess 36 because we're 3, but the 36 of you here on this call, is if each of you actually, furthers the message and multiplies it and spreads the word. So I very much appreciate this opportunity. Because this is a super important election. Every election in the recent past, I feel like we keep saying this is the most important election. But there are presently and will probably be some very important issues that do come down the pike. And I agree 100% with everything you said at the outset. And so I'm going to echo a couple of things that my running mates of sorts have said, but in regards to my race. So I am not on the Supreme Court. I am running for the open seat. I'm presently an appellate court judge, so I did not participate in the boneless chicken wing case, the infamous, what did Colbert call it? Hot legal garbage, if I'm not mistaken. But I am a judge. I am an appellate court judge. And I, much like what Justice Donnelly just explained, when I am reviewing cases, I start with the facts and the law. I do not start with the conclusion that I want to arrive at and backfill. And I think that's a really important distinction, and it's a really important philosophical difference in how different people do this job of judging. I think it's imperative that in order to be open-minded and to do the best I can to check my personal biases is exactly that, is to go where the law and the facts take me and not where my gut says. So that is one thing that I want to be sure that voters understand about me as a jurist, and I will carry that through to the Supreme Court. I also want voters to know and understand that when I am trying to analyze a complicated question, I do not and have never resorted to coming up with my own definition for a word. Seems like a low bar, but I just want to get it out there for the record, to be clear, that when I am confronted with words, I give them their plain and ordinary meaning, as quite frankly, we are expected to do, both as a matter of precedent and statutory guidance. So I do believe that it is imperative that we are guided every day by the proposition that ours is a government of laws and not of men and women, just also to be clear, particularly in this year. But that's a founding principle of our governance. And I never forget that, in part because it is emblazoned above the bench in the main courtroom in the 8th District Court of Appeals where I serve. And I love to read that quote. I love to remind myself of its importance because it is only through that reverence for the law that we actually can ensure freedom for all of us. So that's a little bit about the philosophical reasons that I'm running. And I won't really dwell on my credentials here. Hopefully we'll have an opportunity to talk about that in a few minutes. But I do want to say that I am deeply concerned by the fact that after 57% of the people of the state of Ohio clearly, unequivocally express their preference for reproductive freedom and reproductive rights to be enshrined in the Constitution, our legislature did absolutely nothing, ignored the will of the people in favor of each of those 30 some odd, I mean, there are different estimates, 30 some odd statutes that implicate women's healthcare decisions that are still on the books in favor of having them go through the courts. That is the stated preference of the people in the halls of power. So I think it's very important to remember that when you're considering that the High Court can redefine the word boneless to mean you have no expectation, no reasonable expectation, it doesn't have bones. What are they going to do with the words, every individual has a right to make and carry out one's own reproductive decisions. That's the opening line of Article 1, Section 22 of the Ohio Constitution. So that's a little bit about what guides me, and I'm happy to answer any particular questions. And as
Thank
I said,
you.
I won't really dwell on my credentials here.
Thank you. That's great. We are asking people to put their questions in the chat, and toward the end, we'll have ask Janie Halika to bring the questions before you. As long as we have you going, I'm sort of switching the order up a little bit. We'll go to the next question, which is for Judge Forbes, what particular characteristic most qualifies you to serve on the bench? You may have already answered this a bit, but perhaps you could go on for that one.
Well, I actually really highlight three throughout this campaign that I think do uniquely qualify me to serve on the High Court. One is my expertise in the law. Another is my commitment to community, and lastly is my work ethic. So my commitment to the law comes from 32 years as a lawyer. 27 of those years I was in private practice. For 17 of those years, I was a partner in a national law firm. I was a partner in a national law firm at a time when, even though 50% of graduates out of law schools had been women for at least 10, 15, even now 20 and 25 years, still the percentage of women who are partners in big law, which is where I worked in a big law firm, hovers around 17 to 22% at any given year. I say that because I was a partner for 17 years. I know how to stand my ground. I know how to hold my own. And that is both intellectually as well as personally. Commitment to community, I think, is critical for, as Justice Stewart touched on, you need to be able to understand how the law impacts people. And it's easy to lose touch with that, whether you are practicing law and dealing with lawyers all the time, or whether you are in the ivory tower ruling on cases. And one of the things that I do to demonstrate my commitment to community and maintain my connections with our community is I have been a volunteer member of a board of a social services agency in Cuyahoga County for 15 years now. This is one example, not the only thing I do, but in my role on the board, I have had a hand in important decisions that help deliver essential services to 15 to 20,000 Cuyahoga County residents every year. Those are healthcare services, that's high quality, both physical healthcare and mental health care, Head Start services and other early childhood education, workforce development services, and also recently we've started to, during my tenure as chair of the board, we expanded our services to help try to tackle the problem of the lack of foster care for really desperate kids who have nowhere else to turn. So that is a little bit about my commitment to community, and it really has expanded my understanding of how the law impacts people. And then lastly is my work ethic, which I get from my family. My grandparents are immigrants, or were immigrants, excuse me, they've all passed. But I'm a member of the first generation in my family to graduate from college. And I only got to go to college thanks to work study, waiting on lots and lots of tables, and student loans. I tell you that because I understand that asking for your support and asking for your help to be elected, that I am a living example of the opportunity that my grandparents came to America looking for. And I want to make sure that that's available for generations to come. So my expertise, my commitment, and my work ethic are the unique traits that I would like to take to the Supreme Court, and I think uniquely qualify me.
Thank you very much. Justice Stewart, the same question. What particular characteristic or characteristics most qualify you to serve on the bench or to continue serving on the bench?
Well, as previously stated, currently I'm the most experienced appellate jurist on the Ohio Supreme Court. I mean, there are a couple colleagues who've been judges overall longer, Mike Donnelly being one of them. But that includes trial court experience. For appellate court experience, no one's been an appellate judge on the Supreme Court longer than I have been. So I think one, keeping that experience on the court is vitally important. Second, I'm probably the most educated jurist on the court right now, not only with having a bachelor's degree and law degree, which we all have, but also having the PhD in social science from Case Western Reserve University. So credential wise, and then, you know, I've practiced law. I started off doing civil defense litigation when I first came out of law school, and I was then a law professor, an assistant dean for years in law academia. So I've practiced law, I've taught law, I've written about the law. I've heard thousands of oral arguments over the years. I've written and published thousands of opinions. I think my opponent is up to double digits finally in opinions that he's written. I mean, they're on no planet, to be frank, and I know this sounds self-serving, but on no planet is my opponent better to serve on the court than I am. In my humble opinion, quite frankly, the quality of the court decreased with his appointment. You know, in 2018, over 1.8 million Ohioans elected me to the seat I currently hold. He's on the court by one vote, and that's the governor, who was also a very close personal friend. And you know, and not to sound disparaging, but the two families, the family, you know, the governor's son, of course, is on the court. And so whether the governor appointed his friend as a retirement gift, whether he appointed him to give his son another vote on the court, whether he appointed him because they feared he would lose re-election as a prosecutor in Cincinnati, I don't know, whatever personal and political reasons there are, but I think it should be insulting, quite frankly, to all the citizens in Ohio that the governor has used his political, his power of appointment to put a political puppet on the Ohio Supreme Court. And I mean that regardless. I hope we send a message not only to the current governor, but governors in the future, Republican or Democrat, to don't use your appointment power for politics, and not in our judiciary. There's no place for it in our judiciary at any level, let alone on the highest court. And let me be clear too, it's not just, I don't mean to sound so disparaging about my opponent. It's putting party affiliation on the ballot, which one party did because that was a nonpartisan effort. It was objected to by the Ohio State Bar Association. It was objected to by the Ohio Judicial Conference, which is made up of Republican and Democratic judges. But this politicization of the court has caused me to have to talk more about the stark differences in my opponent and me based on something other than just credentials. And, you know, there's one thing to want the job and there's another thing to want to do the job. Our job is more than just putting on our robes and sitting on the bench and making decisions about cases. As statewide elected officials, we have to crisscross the state in doing things like swearing in other elected officials when they to administer oath of offices to them. I take externs, law students in my chambers every semester, and I work with them individually and grade their papers. And that goes back to my law professor days. You know, it's going to judge moot court arguments at law schools. And my opponent does none of that. My opponent walks into the court with his suit on, sits on the bench. And if you pull up any of our hearings on the Ohio channel, you'll see he doesn't participate. He comes in, he sits in his chair, and he usually votes with the governor's son, and then he leaves. And our job entails more of that. I served on a committee with him and didn't even know he was on the committee. We totally revamped our writing manual, our citation manual. It took hours of meetings. It took hours of poring over and having subcommittees do detailed editing of this manuscript. He didn't attend a single meeting. I didn't even know he was on the committee until it was finally published and I saw his name listed on the committee. And that's the type of thing that, for me, the greatest part of this election, hopefully I am successful, but come January, we both won't be there because my work ethic is such that it makes it difficult to see how much some of us have to work hard to get to where we are while others don't. And when I have that sitting next to me, and the way we sit by seniority, I'm justice number 5, he's justice number 7, by way of getting on the court. So he sits next to me all the time. He sits next to me on the bench. And again, this isn't a personal dig on him because as a person, we're very respectful of each other. We're very cordial. I think he has a wicked, sense of humor. And so you'll be happy to know that as professionals, we both are. When we're at that court, it is strictly about the business of the court. But where we sit next to each other on the bench and where we sit next to each other in the conference room and when we're out in public and that persona, and when we get on the bench and get off the bench, I have to hold the door for him because we sit next to each other. And you'll be happy to know I have never let the door slam in his face, coming off the bench or getting on the bench. So that, I want to say that. But it's just he has to leave the bench in December because he's giving up his seat. He'll have to leave in December. We're hoping that he leaves permanently. And if I don't win, I have over 30 years in this system. I will be okay. I can retire. If he doesn't win, he'll be fine. He's probably already retired. As we speak, we've had court conferences for 2 weeks already. I'm crisscrossing the state campaigning. He's over in Europe vacationing. So he's had more vacations in 18 months than I have in 5.5 years on the court. And it should have been insulting to every Republican judge that he got that appointment, where I'm not so naive to think I wouldn't be challenged, but at least I was hoping I'd be challenged by someone who, if I lost, would still be a good member of the court, would still be a good member of our judiciary. So again, at least come January, either he'll be there and I won't be there, or I'll be there and he won't be there. But I have to say this, and as self-serving as it sounds, I don't mean it. If he wins, the state of Ohio loses.
I don't think any of us would say that's self-serving. It's basically the facts. That's the way it is. It's unfortunate, but that's the way it is.
Yeah.
Justice Donnelly, the same question. What particular characteristic or characteristics would qualify you best to serve on the bench or continue serving?
I think it would be my commitment towards providing transparency to the citizens of Ohio. I have been the most vocal proponent of creating a Ohio centralized sentencing database in Ohio and sounding the alarm about our Ohio sentencing laws that were put in basically in 1996 and how they are programmed to produce racial disparity and just general disparity from courtroom to courtroom. And we just go along knowing this and not do anything about it. The first case that Justice Stewart and I heard on the bench put me on this course of advocacy for this. And this involved a woman named Susan Gwynn from Delaware County. She had been caught going around to various nursing homes and taking certain items of property from the senior citizens that lived there. And she would dress in scrubs as if she worked there. But she wasn't taking items of property that traditional thieves take for resale value on the street. She was taking odd items like family pictures, and some of them had great sentimental value for the people, and the families were rightfully angry. But she was hoarding these in her house in Delaware County, which, as a former mental health court judge, set off an alarm bell for me that there must be a mental health issue at work here. And what happened to her is she was charged with 35 felony burglary charges. She received a lawyer. They negotiated a plea. She pled to 17 of those. At her plea hearing, the state was silent as to what they intended to advocate for sentencing. They went over every possible thing that could possibly happen to her, including several times where the judge said, "Ms. Gwynn, do you understand if I give you probation, what we call community controlled sanctions, you'll have to pay restitution for any items of property that we did not get back to the victims in this case?" She said yes. She entered the plea not knowing what her fate would be until 30 days later. 30 days later, for the first time at her sentencing hearing, the prosecutor stood up and asked for 42 years in prison. Her defense lawyer got up and asked for probation, and the judge said, "You're both wrong," and gave her 65 years in prison. So Susan Gwynn found out on her sentencing date that she wasn't going home on probation that day. She was going to die in prison because she'd have to reach the age of 120. And unlike certain rapists and murderers who have parole boards, she doesn't have that ability under our sentencing laws. This case highlights what Everybody who practices in the Ohio criminal justice system knows you can go into one judge's courtroom, conduct a sentencing hearing, and get probation. You can take those same lawyers and those same facts and walk 15 feet across the hall and wind up with a sentence of 20, 30, or 40 years in prison. This is the facts about Ohio sentencing, and that's why our public has so little confidence in the court system right now, because our judges are told under our sentencing laws that you are to treat similarly situated defendants, regardless of irrelevant factors like the color of their skin or their socioeconomic place in society, with similar sentences. And it's not happening. That judges are not carrying out this mandate because they don't have the information to do it. Time and again, since I've joined the court, I've written 26, 27 dissents on cases that did not get into the court. I could not get a fourth vote, and I started writing dissents. And people ask me from time to time, "Why do you do that?" And it goes back to transparency. I write those dissents because I want the public to know what we're passing on, what kind of issues we're passing on. For instance, like Kyle Dunlap from Licking County. If he's telling the truth, he was told before his plea that there was a private conversation in chambers with the judge, and that if he entered the plea, he would get probation, or if he got any jail time at all, he would get 60 days in jail. So Kyle, believing what his attorney was telling the truth, went in, entered the plea, said the most common lie that happens in our court every single day when the judge takes a plea and says, "Has anybody made any promises to you about what sentence you would get?" "No, judge." They went right to sentencing, and instead of getting probation or 60 days in jail, Kyle Dunlap got 8 years in prison right that day. This is happening throughout the state of Ohio because so many plea negotiations are just a charade that take place in the courtroom, because they're based on backroom deals where things get said in the back room. They never get memorialized on the record, and I'm trying to change that.
Thank you. That's a big important thing. Justice Stewart, let's start with you on this next question. Do you believe that all citizens have equal or adequate access to legal help and the legal system? And if not, what can be done?
I don't believe that all citizens have access. I am the Supreme Court liaison to the OAJF, the Ohio Access to Justice Foundation, that supplies funding to all our legal aid groups and advocates for basic legal education. And, and that's unfortunately, I think, the root problem for so many of our inequities in the justice system. Not all citizens are formally educated. Not all citizens are able to navigate life circumstances, and some people lose their homes or lose their jobs or just can't maintain day-to-day life because they get caught up in the system and they can't afford representation, and then it's just a snowball effect of things that can happen. And so we don't have that access. And I've been an advocate for, supportive of all sorts of clinics and legal aid programs, and legal aid primarily dealing with these legal aid and basic and advocates for basic legal equality dealing with civil issues, because of course the public defenders and appointed counsel deals on the criminal end, but just navigating garnishments and navigating evictions and navigating being able to get your records expunged so you can have some place to live and to work. The overwhelming majority of people in our penal system are not going to be there for life. People convicted of crimes are not sentenced to life in prison, except for Mrs. Gwen, unfortunately, or are not sentenced to death. And so these people are going to come back out. And when they come back into society, what would we rather have? Reintegrate them into our society and make it so that they can have some place to live and be productive members of our society and pay taxes and be good neighbors? Or would we rather have them re-victimize us again? Sure, get caught, maybe prosecuted and put back in the system, but I'd rather us not be re-victimized. I'd rather them go on to have productive lives and keep us safer too. So it's always a continuous problem. One of the things that recently happened is even in our rural communities, so many lawyers who come to Ohio or who graduate from law school, they stay in our larger counties. I mean, Cleveland, Cincinnati, Toledo, Dayton, Columbus, Akron, we have tons of lawyers, but the communities in Washington County and Meigs County and in Morrill County, they don't. And so there's an initiative that we have to try to get law students to go back to those communities or go into those communities to serve that population too. So it's not just a matter of funds, it's really a matter of access, and we've just got to do better than this.
Thank you. Justice Donnelly, same question really. How are you viewing legal access to the legal system, whether it's adequate or whether you would suggest something that would be done to improve access?
No, it's not adequate. Last night I was at what I consider one of the most important institutions in Northeast Ohio. That's the Cleveland Legal Aid Society, a benefit. And I've been a strong proponent of legal aid and access to justice since running for this. There's a huge justice gap in the state of Ohio between the people who can afford legal services and not, and we're not providing the access that we have to. I would promote what certain states are doing, like in Portland and in Washington, expanding the authority of paralegals to assist people of meager incomes to have access to the courts. If you're in an abusive marriage, you still need to get a divorce. And our domestic relations courts right now, unfortunately, are causing the biggest threat to public confidence because they are so filled with delay and complexity for people who don't have attorneys to get. There's a domestic relations case right now in Ohio, which the people are fortunate to have attorneys on. They filed it in 2017. It is still pending right now. That a divorce case between two people, a doctor and his wife. That's what happens in those courts because the judges let the attorneys run the courts. They continue and continue and continue, and that's why people are so frustrated with the court system. We should be provided a streamlined process. Courts are there to resolve disputes and protect your rights, and we are not doing that as efficiently as we can. And that's what I'll work on if I'm reelected.
Thank you. Judge Forbes, same question basically. How do you see legal access to the legal system?
Yeah, I mean, I'm gonna agree with my my colleagues here that, yeah, I don't think that all citizens have equal access to legal services. One of the things that I have done in my experience was to try to help people at the appellate level. So criminal defendants are appointed counsel if they are indigent, but indigent civil parties do not have the same opportunity. So one of the things that that we did, and you only have 30 days from the entry of a final judgment to get your notice of appeal on. And if you miss it in civil proceedings, it is gone and it is irretrievable, absent extraordinary and very unusual circumstances. So what I was involved with a Cleveland Bar Association initiative that tried to increase information to pro se, that's self-represented individuals, for how they could get legal help. And that was through providing notices. And now our court does this every time a pro se appeal is filed. We get information to the parties about the availability of help through legal aid through the law schools. The law schools have clinics, and sometimes they will take on people's self-represented individuals' cases. And so we also have that the trial courts provide similar information, or there's a process for getting information within the 30-day time period. So, I mean, that's just one example where if you don't have a lawyer who understands what the rules are, how are you going to be able to perfect your appeal right? So that's one of the things that I did work on. And yeah, I mean, I agree with everything that Justices Donnelly and Stewart had to say.
Thank you very much. Appreciate it. Next question, and this goes to Justice Donnelly. What do you see as the greatest obstacle to justice in our state?
I would say the lack of transparency that exists in our criminal justice system. 97% of cases in our criminal justice system are not resolved by people exercising their constitutional right to go to trial, as our founders envisioned they would, once we ceded to the government the power to charge criminal charges and take away what we value the most as Americans, our freedom, as punishment. And the system has become not a matter of trials, truth and trials, but it's become one of pressure and pleas. And a lot of what these pleas, like appellate court judges like Judge Forbes, never see these pleas because pleas don't get usually appealed. The vast majority don't get appealed, and the vast amount of these pleas are negotiated back in judges' chambers. And I didn't do that when I was on the trial court. I did something different than my 33 colleagues because I didn't believe that anybody should say something in the back room that they wouldn't repeat verbatim on record. So one day I said to my bailiff, "Hey, John, we're going to do things differently. Everything is going to be on the record. That way, everyone's held accountable for what they represent, including myself. And if I say something that induces someone into a plea, make a representation about I'll go along with this sentencing recommendation, then 30 days later, I don't get to change my mind because I'm in a bad mood or I forgot what I said 30 days earlier. It's all there on the record. And that's what we need to change to provide more confidence in our public, in our criminal justice system. And what we have to reform sentencing and make it more equal for everybody and access.
Thank you. Judge Forbes, same question to you. What do you see as the greatest obstacle to justice in our state?
I'm actually going to give you two answers, and one is in fact and one is in perception. And I would say that a significant obstacle, I'm always hesitant of superlatives, but a significant obstacle to justice, in fact, is the lack of information, the lack of consistency, so that one individual who is sentenced for a crime in one courtroom may receive a significantly more severe sentence than an individual sentenced down the hall by a different judge, similar facts. And it's difficult for the judges, quite frankly. They don't know what's going on in other courtrooms. And in fact, unless you're one of the few judges who actually maintains your own data and statistics, you can't even compare within yourself, right? You can't even say like, oh, 3 years ago, I was doing it this way, and then this year I'm doing it that way. You may not even be aware that things have changed within your own system. And again, that's just the lack of data. Now, some judges do maintain their own data, but then there's no comparisons across courtrooms. So I think that lack of consistency is significant. And then the perception issue I'd like to touch on as well, because I think that when justice is a concept, right? It is not just a mathematical equation that we know exactly what it looks like, and we can compare it one day to the next, one person to the next, one case to the next. And I think that one of the things that is very distressing to me in terms of people's confidence and faith in the justice system, and thus the perception of a just justice system, is this politicization of our courts. We judges, I believe it was Justice Donnelly who said earlier, we judges, when we zip up our robes and we take the bench, we are there to do a very specific technical job, and that is to apply the law. And that shouldn't matter whether you're a Republican or a Democrat. It should matter what the law is and what the facts of the case are. And when we have this situation where people are encouraged, quite frankly, to think of us as political actors, then I think that it really demeans the justice system, and it diminishes people's confidence in the legal system. And I would say that that is a significant issue, problem that we do need to address as a community.
Thank you very much. Justice Stewart, same question to you. What do you see as the greatest obstacle to justice in our state?
I think the number one is implicit or unconscious bias, which we all have. I mean, you know, it's impossible not to. We bring our background, we bring our training, we bring our upbringing, our environments, what we take in the media, all of that, and we all have it. And I think the more we recognize that we have it, the better we are to maybe ward against it. One of the beauties I like of being an appellate court judge is, you know, we just, more often than not, most of the times, we just get the facts of the case and what's going on. And we don't see the defendants, we don't see the parties, we don't see, you know, race is not an issue, gender is not an issue, age is not an issue, unless it's specifically noted in the materials that we read. And so it for me, helps to protect against potential biases. And when I say bias, I don't always mean negative. I mean positive too. You know, sometimes we have positive biases in favor of one group that's to the detriment of another group. I mean, you know, if three people committed the exact same crime, if one was a 20-something-year-old, one was a 40-something-year-old, and one was a 70-something-year-old, would we feel the need to incarcerate them all the same amount of time? Would it matter based on their ethnic backgrounds or their level of education or their level of wealth? At a recent judicial conference, a judge who was in his last term, who used to be a trial court judge, an appellate court judge, was telling me about a case once where a couple left their child in the car on a hot summer day and ran into the store. Someone saw it, called the police, so they were convicted. I mean, they were charged for child endangerment, didn't have the means to have a lawyer, pled guilty, and he sentenced them, you know, to some time in jail for that offense. He said, a little less than a year later, about 10 or 11 months later, a similar situation happened where a gentleman left his child in the car in the summertime. It was hot, and was charged for the same crime, had a lawyer, was a fairly well-off person, and he was given probation. And it dawned on the judge that he had treated two identical crimes, identical situations, differently based on who the defendants were. Now, the couple was a Black couple, an African-American couple. The gentleman who left the single gentleman was a white male. And they didn't happen back to back. And it dawned on him that why were there different outcomes for these identical crimes? And it bothered him. It bothered him so much so that he brought it up at a judicial conference. And he admitted too that he's somebody who was always told to never trust Black people. He was raised in his household to treat that. And it has influenced him as a person and as a judge. So we just have to recognize, and it's not to say he came from a bad family or an evil family. It's just, it is what it is. And we bring those things with us. So I think implicit and unconscious bias is first and foremost. Second, I think is just the lack of data. that informs our decision making. You know, we elect our judges, you know, that's just the way it is. So we have a turnover in our judiciary every year, either in the municipal courts or in the odd number of years, or the Supreme Court, Court of Appeals, and the common pleas courts on even number of years. And so every time we come in, you know, getting elected and putting a robe on does not make us all knowing. And I think a backlash to not have data inform our decision making is a travesty. I don't think it should dictate how judges make their decisions, but again, to inform our decision making. And I am, quite frankly, having been in the system so long, I'm appalled that we have a system that is not better. We don't have a better judicial system. But we could if we didn't have the turnover. Just every group that comes in, you know, relying on what he or she knows. So I think implicit bias and the lack of data.
Thank you very much. I'm going to take a pause here. We have a few people that have just come in. When you come in, if you could put your name, your location, and if you wish any affiliations you might want to share in the chat. We will be recording these, but we want to also have a record of who is in attendance. We are going to be forwarding questions toward the end of this session. And now I'm going to skip a little bit. I think we've already answered the next question. So I'm going to go into something that Justice Stewart touched on, and I'm going to start with her this time. Can you recommend any changes in the way Ohioans select their judges?
I'm sorry, was that posed to me?
Yes, yeah, we'll
Okay.
start with you since you sort of touched on it about selection of judges, how we run things here in Ohio.
Yeah, I think, you know, Ohioans have spoken. I think when retired Chief Justice Maureen O'Connor first, around the time she became Chief Justice, she put out or had put on the ballot whether we should continue to elect our members of our judiciary. And that was met with the answer yes. And although some people say I don't have a clue what all these different judges do, and the judiciary is the least understood branch of government, you know, we still want to continue to elect our judges. So we do that. However, I think the politics involved in our judges, in our electing judges, I don't think there's any place for that. So having party affiliation on the ballot, I think, is not a good thing. And I would think that if the Democrats controlled we have a Republican-controlled executive branch of government, a supermajority in the General Assembly, and a majority in the judiciary and the Supreme Court. So one party controls all the branches of government for our state. If it were controlled by the Democrats, I would feel the same way, particularly for the judiciary. I don't think people and lawyers should be able to say we're likely not to get this ruling because this judge is a member of X political party. However, I think there needs to be better mechanisms to hold us accountable. And I think there needs to be maybe some retention, and not based on how a judge rules, but if a judge leaves a motion pending for 14 months and lawyers get ready for a trial, and then the judge rules on the motion, look at how much money it's cost the parties to prepare for trial that doesn't go forward. That's wrong. Mike Donnelly talked about a divorce case that's been pending for years. That makes no sense. But those are things that judges aren't held accountable for. It's not the lawyer's fault all the time. It's the judiciary. We should be the ones who police the effective and efficient act of government. And even in my race, at the end of last year, when we were finishing up hearings, my colleague opponent, was nice enough or kind enough, if you will, to come over to me and say, you know, Melody, I see you and Mike filed your petitions. I just want you to know it's going to be you and me in 2024. So I was shocked that he was, you know, he was kind of hovering and hovering around in our conference. And I thought either he was going to propose to me or he was going to tell me he was going to run against me. Since he's married, I figured it's the latter. But, you know, he says, you know, and I said, you're going to run against a sitting colleague? And he said, I know, I hate it. It's detestable. It's terrible. But I have no choice. And what do you mean you had no choice? You can run for the seat that you were given. No, I was told to get the appointment, I had to run to take out one of the two Democrats. So that's what our judiciary has become. And there's no, I mean, to have, I think, that effective and efficient and more confidence in our judiciary, we've got to take the politics out, and we have to be held accountable. You have to elect us and you have to hold us accountable. You might not agree with every decision, but particularly on a court that has more than one member just making a decision, the Court of Appeals, which all Court of Appeals has 3 judges sit on the panel, and the Supreme Court, we always decide by 7. For those courts, we have to be held accountable. The trial court judges who run their own ships, their own silos, they really have to be held accountable with how long it takes for them to rule on cases, on lack of consistency, on mistreating litigants in the courtroom. And if you've been watching us, Supreme Court, we've come down harder in the last, I'd say, 3 to 5 years on lawyers and magistrates, I'm sorry, judges and magistrates, who really shake the confidence of the public in using their judicial authority to inappropriately and incarcerating people for things they shouldn't be put in jail for. And so we vow to protect the public that way, and we hope it sends a message. But we need to be held more accountable, and that's where the public and the citizenry comes in.
And would you say that the holding accountable judges and magistrates accountable can only happen through elections, or is there another method that you would suggest?
I think there can be maybe a hybrid method. I think if the people in Ohio overwhelmingly decide that they still want to elect their judges, then I think after that term, those judges maybe should be evaluated for retention. And if those judges have provided good public service, meaning, done their jobs, don't have late dockets, treat people with respect in their courtrooms, rule on motions in a timely way so it doesn't cost litigants time, and at the appellate court level, don't sit on opinions too long, justice delayed is justice denied. So maybe we elect our judges and have some system that evaluates, that has some accountability and evaluates whether that person should be eligible then to run for re-election.
Okay, thank you. Justice Donnelly, same question to you. Can you recommend any changes in the way Ohioans select their judges, and maybe tie that also to the issue of accountability that Justice Stewart mentioned?
Yes, I agree with Justice Stewart. I think that the best system would be an elected nonpartisan system, not having partisan primaries, no partisan general, and then a retention and to get the politics out. If a good judge is doing their job right, he or she should remain there, but there should be a mechanism for the public, if they're not doing a good job, to take them out. And I'm not one of these people that, just because I'm a judge, I stand up and say all judges are good. They're not. And I'm very happy with disciplinary counsel who is currently going after judges who abuse their power. We suspended a judge who was conducting a probation violation hearing and asked the defendant, who he was scolding and talking disrespectfully to, who the woman in the back of the courtroom was. And he indicated it was his girlfriend, who was a spectator in the room. And he said, "Is she on drugs too?" And he said, "No." And he goes, "Well, I'm going to have her drug tested." And he ordered to have the spectator arrested and put in jail. And we suspended him for 2 years because, some people get into these jobs and let the power of the job go to their head as if they were, and believe me, there's not too many positions in Ohio government more powerful than the Common Pleas General Division judge, who, like mentioned in the Gwynn case, if you have guardrails on your discretion from probation to 160 years in prison, that's the fertile ground for implicit bias that Justice Stewart was talking about. So there's no perfect system in selecting judges, but getting partisanship out, having to run every year and raise money, which raises the appearance of impropriety. I've made a commitment. I will not take any money from any utilities in this race, from First Energy or anyone, or likewise their opponents, Consumer Council. I will not take any money. We have too much direct supervision over the Public Utilities Commission. I didn't know that when I ran for the position, but I'm not taking any money from any of those PACs because we have to maintain, that we are impartial in these decisions. I get the question a lot at law schools from students, and they think that, well, what about the U.S. Supreme Court? Aren't those people the most qualified? And I asked them. I was at the University of Cincinnati. I said, really, do you really believe that? Look at what you have to do to be on the U.S. Supreme Court. It used to be you had to go to an Ivy League school, Ivy League law school. Now that's not even enough. You had to have clerked for one of the previous U.S. Supreme Court justices, and they have to give you their blessing. So it's an all insider, it's the politics of the few as opposed to the many. A valid criticism against our system right now is most people don't know who we are. And fortunately, there's organizations like this organization who wants to know and wants to tell the public who your judges are and what they stand for. And I'd rather have the politics of the many as opposed to the few, because the public always has the opportunity to educate themselves. And if there's a bad judge, you can take them off the bench.
Thank you. Judge Forbes, same thing. Can you recommend any changes in the way Ohioans select their judges? And if you could also include the other issues about retention and other possibilities.
Sure. Yeah, I think that we do need to get politics out. We're one of a small handful of states that do it the way we do, with the partisan election, followed by partisan primary, followed by now the partisan general election for Supreme Court and Court of Appeals judges, and even for the common pleas judges being and municipal court judges being nonpartisan. It's still like the patina of partisanship is just glossing all over everything. So I think that it's important that we get partisanship out for the reasons that we've already talked about. I mean, I think it is unfortunate that people do not have confidence in judges ruling independently, because we've shunted the judges into these political roles. I think it's important to remember that, yeah, I'm not saying I'm not a proud Democrat. I am a proud Democrat, but that's not what I am when I'm on the bench. And I think it's just important to remember that judges don't do the same kind of job as executive branch and legislators. Legislators horse trade. I can tell you, I'm on the Court of Appeals, and at no time have I ever had a conversation with a colleague saying, I'll vote to affirm the conviction in this case if you'll vote to reverse in that case. I mean, it just doesn't happen. And it would be wholly inappropriate if it did. And to leave the impression that could is I think it's doing a disservice to the judiciary, and it is misleading to the public. It is not providing meaningful information to the public. So first and foremost to me is getting partisanship out. How to accomplish getting partisanship out? I think everything that Justices Donnelly and Stewart have said is, it really makes a lot of sense. Maybe go to some sort of a retention system. I think it would be enormously helpful if there was some mechanism for the public to know what kind of work we do, right? And that is not readily apparent to most citizens in the state of Ohio. Like the number of people who read my opinions, it's a tiny number, but that's for good reason. But if there were some sort of a clearinghouse of information with some baseline information that would be helpful to inform the electorate, I think that would be a really tremendous starting point for having meaningful retention elections.
Great, thank you very much. I want to make sure that we have a little time to throw out questions from the chat. We do have a couple more really important questions, but I think maybe we'll just take a little pause here. If the justices and judge have time to respond to a few questions from the chat, is that acceptable for you? Everybody
Yes.
okay with that? Okay, great. I'm going to ask Janie to throw out the first question that came up on the chat.
Okay, I have a question from Nancy Fingerhood. What are your thoughts on hearing directly from children when there are allegations of abuse in a custody case? And how do you determine whether or whether not to speak directly to the children in chambers
Or open court.
Okay,
or open court?
okay, let's start with Justice Stewart on that one.
Well, again, we're talking about things that happen at the trial court level.
Yeah.
That's kind of a little bit out of my wheelhouse. But I think the decisions that are being made at the legislative level, federally and statewide, to protect children, I think is critically important. I know that there have been, particularly in domestic relation cases, and I'm sorry, yes, domestic relations being divorce and child custody proceedings, et cetera, that there are times, and I really hate this, and it's unfortunate, where one parent might use allegations against another parent for custody or for child support or for visitations or vindictiveness, et cetera. I believe, and this is strictly anecdotal, this is no science behind it or no data behind it, I believe those cases are rare. And then if you have to err on the side of one way or the other, you gotta err on the side of protecting children in whatever way that's possible. So I hesitate to at least give my thoughts or and they would just be strictly my own thoughts and feelings about what's to be done to be able to discern that and protect kids. What I will say is our system needs to be better. I know in Cuyahoga County here, as a matter of fact, the county exec is building, or our county officials are trying to put together build a facility where when kids are dropped off, or kids have to be taken out of homes, or kids are found in the street, or just some horrendous situations, they aren't dropped off at an administration building, and that there's some place for them to go. I'm alarmed about the increasing amount of children who are being victimized, who are being abused, who are being neglected, and those are just the cases that we know. So how that gets treated at the investigative stage and at the adjudication stage, I think is critically important. And I know it's something that even with our committees and our boards on the Supreme Court that we're paying close attention to. But of course, our judicial capacity is limited to those cases that only get up to us, that come before us.
Thank you very much. I would just ask generally if Judge Forbes or Justice Donnelly has something to add to that. I'm guessing that may be similar, but if you've got something to add to what Justice Stewart said.
Just one thing. In the next 2 months, you're going to see a lot of money spent by our opponents and dark money spent in these races. And I predict that they are going to try to paint the three of us as soft on crime, and that we don't care about public safety. And nothing could be further from the truth. I was a trial court judge for 14 years. I began my career as a prosecutor. And I feel very strongly about our obligation in the judicial system to protect children and protect all victims of violence. If you Google my name, you will see that I led an effort before I was on the Supreme Court while I was a trial court judge to bring more transparency to the plea bargaining process, because what I saw in other courtrooms where judges still did the backroom deals, they would allow, particularly in felony sex cases, they would allow the defendants to plead to crimes that have nothing to do with rape or the crimes they were charged with. Completely legal fictions of what the lawyers call them. And I led an effort all the way to the Republican-controlled Supreme Court to change that, and they rejected the idea. And you can still Google this Dispatch headline and read all about it. It says Ohio Supreme Court rejects truth in sentencing rule. This was in 2016. So I keep data on all the time, in all the jurisdictions that I can, where I can collect Cuyahoga County, Hamilton County, where my opponent is. And I see that this is happening. They will plead a rape case down to a charge known as aggravated assault. Aggravated assault is not a sex crime. It has nothing to do with rape. The public doesn't question this. The person, if they take that plea, they don't get subject to a sexual registration law as someone who commits a sex offense would. And this is what they're doing. And I continue to sound the alarm from that. Prosecutors don't like it when I do this. But I'm sorry, I don't believe this is in the interest of justice, letting people who may have committed most serious sex offenses plead to something that they didn't do. This is not fair to victims in this state who deserve accountability for being victimized by their perpetrators.
Thank you. Judge Forbes, do you have anything different to add to that question from the chat?
No, but I will note that that Child Welcome Center that Justice Stewart was referencing is actually going to be administered by the centers, which is the organization I was talking about earlier.
Okay, thank you very much. Janie, do we have any
Yeah.
other questions
Yeah.
in the chat?
We have another one from the same,
Nancy.
from Nancy, and I don't know if they'll have any more to add to this, but let me just ask it. What are your thoughts on HB 14 to default to equal shared parenting in custody cases? I don't know if you'll have any more to say about that or not.
Okay, let's go to Justice Donnelly on that one.
It's hard. We're not allowed to speak about policy related matters that might come before us under the judicial canons. I could say, generally speaking, when we decide about cases coming into the Supreme Court, only 4% involve domestic relations type cases. Usually it's someone just upset with the ultimate decision. But in cases that involve parental custody, those kind of cases, and I think I speak for all the justices, look at those cases very carefully because we consider those matters very significant. And if they're significant enough that they would affect other cases, or even if it affects that case and there's an injustice taking place, I will vote for that case to come in for review.
Thank you. Did Judge Forbes or Justice Stewart, do you have anything to add to that one?
No.
No.
All right,
Okay.
thank you.
We
Yes.
have one other one that relates to the judges, and then we have one on citizens, not
politicians.
which we'll
later.
deal with after. Okay. This question is from Penny. What are your thoughts when a person's due process rights were ignored, stated in court documents individual was served, but not served, and the court allowed this abuse to occur? How do you address the problem when a court punishes a person for exercising her First Amendment rights?
Anybody like to field that one?
I would just say generally those kind of cases when someone, if that's the allegation that's coming forward that happened, those are the ones I tend to gravitate for to bring in as matters of great public importance when people are denied their right, or when people receive a trial tax for exercising their right to go to trial in a criminal case. The law, we say, prohibits a judge from giving more time to someone who just exercises their right. But in Ohio, there's a case called State v. Rahab that was decided before Justice Stewart and I joined the court that said that dealt with a trial court judge who was trying to urge someone to enter a plea because the state offered a 5-year prison sentence. And then when they wanted to go to trial and exercise their constitutional right at sentencing, the trial court judge said, you had to be a gambler, didn't you? Now I'm going to show you what happens to gamblers, and sentence that person exponentially more severe than what the plea offer was. And our Supreme Court said, oh, while the judge's words may have been somewhat intemperate, it didn't mean she was delivering a trial tax. That's the law. So basically in Ohio right now, a judge has to come out and say, I'm about to give you a vindictive sentence in order to be subject. And I don't even know if that wouldn't be held as harmless error, the way appellate courts are so deferential to trial court judges.
Wow. Thank you. Judge Forbes and Justice Stewart, do you have anything to add or to that question that was from the chat?
Just that it's difficult to address what seems to be a very particular and fact-specific scenario.
Right, and I will just say too, in general, you know, for those of you who don't know, maybe this is helpful to get, you know, any case that happens that you institute or that is instituted against you in the trial court, and I mean anything, traffic ticket, speeding ticket, termination of parental rights, medical malpractice lawsuit, planning and zoning decision, mineral rights. If you think a mistake was made at the trial court level, you have a right to appeal that decision to the appellate court. We have 12 appellate courts in the state of Ohio. You have an appeal as a right. If it's a final order, you get the appeal in timely, you pay the cost, whatever. You have an absolute right to appeal what you think was error. You don't have a right to get into the Ohio Supreme Court. With we overwhelming majority, with rare exception, some direct appeal authority. We take all death penalty cases. We have to. That's a direct appeal. Public utility cases, as Mike spoke about earlier. But most of the appeals that come to our court are called jurisdictional appeals, where we get to decide whether we're going to even hear it, whether we're going to let it in. And there is criteria. It's supposed to be based on, you know, whether cases of great public interest or important to the state of Ohio. And so it's got to have certain criteria because we have to sit, there's just 7 of us. We accept less than 5% of the cases that get appealed to us. Every other week, we go through 30 or 50 potential appeals coming to our court. Sometimes we accept 2, sometimes we accept 1, 3, sometimes we accept none. And so realizing too that our criteria should be, we shouldn't pre-decide what that case, the outcome should be. It should be, does this case present an issue that is of great significance to the jurisprudence of the state of Ohio? Do we have to resolve something that is going to be potentially devastating to a certain industry down the road, or we'll have conflict in the law going forward? If we don't take in those cases, then we've already decided, a decision is made to let the law stand the way it is at the Court of Appeals level. And so if you're going to be outcome oriented, results oriented, sometimes you're going to vote not to take a case in because you want the law to stay what it is, or for fear that the law might be changed. And that should not be the criteria that we use. We should take in all cases, regardless of what the ultimate decision would be, if it's a case that the Ohio Supreme Court, the highest court in our jurisdiction, should decide and should weigh in on for the sake of stabilizing the law in a particular area.
Thank you. It's very helpful. Janie, are there any other chats before we continue?
There's one more that just came in a few minutes ago, and it's from Greg. And it says, what are your thoughts on the fact that the cost of legal representation has become so high that many people, even innocent people, simply can't afford the thousands upon thousands of dollars it costs to go to trial and risk getting punished with a trial tax?
Okay. Yes, Judge Donnelly.
Yeah, I think that's a great observation about the reality of the criminal justice system right now. You know, back in the 1980s, all the crimes that could be prosecuted against an individual were contained in one book. And over the years, this legislature has hyper legislated the criminal code and is now in 6 different books. And all those laws and specifications all act as bargaining chips and leverage that the government uses in order to induce pleas. And it's become so coercive that an innocent person in some cases would be a fool not to take a plea because of the consequences that they risk by going to trial. And for innocent people, like Greg mentioned, there's a problem. I just wrote an article for Cleveland State Law Review called the dark plea. This is a term that is gaining traction across the nation. I've coined the phrase. In Ohio, if you're innocent and you have evidence that, if true, would undermine the theory of guilt that was used to convict you, you are not entitled to a hearing to present that evidence. You can file a motion and ask for a new trial, and the state can oppose it with another written motion, but the judge doesn't have to hold a hearing. So if the only person who voted or testified against you at trial recants their testimony and the state says you shouldn't believe them, the judge doesn't have to hold a hearing. They could just say, I don't believe them, and deny it right there. And so innocent people have to litigate for years to sometimes just get a hearing. And if they're lucky to get a hearing, what prosecutors are doing, if they think they're going to lose at that hearing, they'll go to the person and with no charges pending, and they'll say, we'll withdraw our opposition to your motion for a new trial and let you out if you plead guilty to what we already convicted you of. This is what I call the dark plea. And it's the legal equivalent, in my opinion, of pointing a gun to someone's head and forcing them to confess to something. So people end up taking these pleas, and then they're saddled with a conviction for the rest of their life. And if you want to read about this, please contact me, and I'll provide you with a copy of my article.
Thank you very much. Maybe on a follow-up, when we send the recording out, you could send me the link to your article.
Yes.
On email, or have the campaign do it, and I'll be able to get that out. That would be great. If just Judge Forbes or Justice Stewart, if you have things that you would like to share with the people that are going to be receiving this recording, please again send it to me, and I can make those things available.
Okay, Debbie, and one thing I did put in the chat there too was
Yes, okay, great.
judicialvotescount.org, which is
Yes, yes.
nonpartisan, doesn't make recommendations, doesn't do endorsements, just allow really, I think, a great public service to anybody. Go in and click on their county, and it will tell you every judge who's running in your county, and will provide background information if he or she chose to do so. And just gives you, it's a one-stop shopping for information about judges on your ballot.
Right. Thank you very much. We do include that. Indivisible does include that as one of the resources for judicial candidates.
Right.
But it's really good to have that reminder, and it would be nice to have as many things as you all three feel are important to voters to have background information for. That would be great. I think that was all that we have from the, unless Judge Forbes, if you've got something to add to that last question.
I'll just say that I see somebody put in the judgeforyourself.com link as well. And that's just another way to get information out. I'll say it's going to be increasingly difficult, I think, to get balanced information because, on Judge for Yourself, our opponents didn't present themselves for consideration. And I just am about to have my interview at the Plain Dealer. I received information today from the Cleveland Plain Dealer that the Republican Party informed her that none of the Republican candidates are going to participate. And I think I say that because I want you to know, in the spirit of transparency that you've heard so much about today, I appreciate that maybe not everybody on this call or not everybody in every audience I speak to is going to vote for me. But I'm going to say the same things about myself, about my record and my philosophy, because I think it's important. So these are important races. And as I think we've all made clear, you need meaningful information. So I think that in and of itself is information that we need to bear in mind.
Thank you very much. Appreciate that. And we will do that. We will get as much information out as we can to help people make those kinds of decisions. I don't know how much, I don't want to burden the justices because we're already at 1:30. But if they're willing and everybody's interested, I do have a couple more questions that are kind of biggies, but I'll let it be up to you. I don't want to hold you guys up. So Justice Donnelly, Justice Stewart, and Judge Forbes, how do you feel about another 5 minutes or so?
Yes, that's fine, but it was mentioned that, there was gonna be a question about, one person, one vote. And we have litigation that was just filed about the ballot language on that, so we were prohibited from talking about.
Right,
Right.
yes. Yeah, we
Um,
understood that you would be prohibited from that because it's likely to come before you. Did you have a general comment you wanted to make about it, or?
No, I think it's public knowledge where we stood during the last redistricting ballot. We were in the majority that threw out the unconstitutional maps, Justice Stewart and I think if you want to see our positions, Justice Stewart wrote the opinion in the state legislative maps, and I wrote the congressional maps. So,
Right.
I'd urge all the people who are interested, and rightly so, in this very important topic that Maureen O'Connor is leading the fight on.
Right.
I would urge people to read those decisions.
Thank you. That is something that Indivisible has been working on pretty hard. So and we all have a big stake in that. Many of us have worked on redistricting issues for a number of years, and so it's dear to our hearts. But we do understand that it may come before you on the bench. In fact, it likely will. So we know that you're kind of prevented from telling us how you'd vote. We can just surmise from the past, and go with that. I do have a couple of questions. Do you have a few more minutes to spend? And if you have to drop out, I certainly understand. And in advance of that, if you do need to go ahead, I just want to thank you three so much for joining us. It's been extremely instructive, and we just really appreciate it. It's just extremely helpful. And we know that those who can't join us today, it is being recorded. So there's a larger audience that will receive this information. And again, we thank you for permitting us to record it too. And in the interest of transparency, it's nice to have as much information as we can before we elect our justices, because we do know how very important they are. Okay, the next question is, it's fair to say that most voters want judges and justices to be independent of special interests. How would you personally maintain impartiality and avoid undue influence? Let's go to Justice Stewart.
That's absolutely easy for me. I've done it my entire judicial career. I'm not an outcome-oriented person. If the law's on your side, based on what the statute says, what stare decisis has been in a case, if the law's on your side, you should win. I remember being on the Court of Appeals one time and saying, my mother was the star. My North Star was the person who I adored and treasured the most, and who, although she's been gone for 24 years, is the person who built the foundation for who I am. If I had to sit on an appeal from my mother's conviction, which would never happen, of course, I could never do that. But if the law favors the state, I could affirm my own mother's conviction. Is just how I can apply the law, which sounds crazy, but that's what I'm supposed to do. Now, does that mean I wouldn't visit my mother every day? And of course, I would still be her daughter and do all the things that family members do. But if the law was on the side of the state on an appeal of her conviction, I could do that, because that's just how detached, I guess, I am, except when it does involve something emotional. And I feel that, as one of us said earlier, that the law works in injustice. The beauty of being an appellate court judge is you get to write about that. And so I'm never afraid to what my political party might think. I'm never afraid of what the public might think. I take an oath to uphold the law, the constitutions of the United States and the state of Ohio. And I do that at every turn. And again, if I see some injustice that the law exacts, I'm going to write about that too, but I'm still going to apply the law because people need to know and believe that when the law is on their side, they should win. And when we see biases that rear or people being treated differently, and then I mean that from individuals or corporations or governmental entities or small businesses, period. They should feel that everybody who comes into our court is getting a fair shot at having their case adjudicated properly. So I've
Thank
never had
you.
any problems.
Yes. I think that we've heard similar responses from Justice Donnelly and Judge Forbes about putting the law and first. There's a related question though, since we're short of time. I'd like to send this one to Judge Forbes. What, if anything, would you do if one of your colleagues on the court is not acting in an impartial way or refuses to recuse when there's a conflict of interest? And I know the other justices have been in this situation, so I'm asking Judge Forbes about this one.
What would I do?
What would you do if a member of the court that you're sitting with, a colleague, is acting in an impartial way or refuses to recuse when there's a conflict of interest?
Well, I think there's sort of two parts to your question, actually, Debbie, because there's a legal conflict of interest, and then there's the appearance of impropriety question. And I will also just give you a smidgen of background here that, like, I am bound by, because the Supreme Court would check or could check me, but as an appellate court judge. But there's really no higher authority when there's that consideration with regard to the Supreme Court. So, and I say that because, for example, if that scenario played out in an appellate situation, the party who felt that the judge on their panel should have recused could move to disqualify the judge, and would move in the Supreme Court to disqualify. So it's a slightly different question. I know that's not really what you were trying to get at. So I just want to offer that as background because it's just not a scenario I've had any experience with. Because of the different context in which I sit in the Supreme Court. So, but I can say that if I were concerned that one of my colleagues shouldn't be on a panel, my first course, I believe, although again, I've never experienced this, would be to talk to them to try to understand why they're still sitting on that matter. Perhaps there's something about it that I didn't understand that did distance them from the circumstances. But I think from my remarks earlier, I've already made quite clear that I believe that it is important that we guard against the appearance of impropriety every bit as much as guarding against actual impropriety. Because I think that is the way to build public confidence in the operations of all the court system.
Thank you very much.
If I can just chime in on that too.
Sure.
You all should know that if somebody feels that a jurist at the trial court level or the Court of Appeals if they are asked to recuse from a case and that judge refuses to do so or doesn't think he or she should, you can file an affidavit of disqualification in the Ohio Supreme Court. The Chief Justice is the sole decider of that, and the Chief Justice can remove a judge from hearing a case if the Chief Justice believes that there is legitimate concern of bias or impartiality. That same affidavit of disqualification cannot be filed, however, against a Supreme Court justice. So one in the chat asked about it, one of our colleagues not recusing. The 7 of us are the monitors of ourselves. Now, we can always say informally, are you kidding? You're really going to sit on that case? We had an example this year where my colleague, junior colleague opponent, sat on a case as a justice, and that was tried and appealed when he was the prosecutor. A lot of people think that's a terrible conflict. Ironically, that same day, we also heard another case that had one of the attorneys who was one of my former law clerks. And I recused from that case because I didn't even want the appearance of impropriety. I didn't know what the details of the case was about, but I didn't want anybody thinking, if I voted on her position, I didn't want anybody thinking I did that because she was my former law clerk. So to me, that was the appearance of impropriety. People need to believe in the integrity of the system. And although I have no doubt I would have been fair and impartial, even if I ruled against her client in that position, again, it's the appearance. And so we have to police ourselves, but the seven of us don't have, you know, we are more responsible for policing ourselves, because you can't ask us to, you can't file an affidavit of disqualification against us. But I think it's important. I don't think I am such a brilliant jurist that there's no case that can't be decided without my being there, particularly when there's 6 other votes. I can't do anything without 3 other votes. And so to protect the integrity of the judicial system, I will always err on removing myself from a case.
Thank you. Appreciate that. There's one more question, and I don't want to take any more time, but this one is, we're running up against it quite a lot. In high school civics, we learned that the 3 branches of government are co-equal. However, we saw during the redistricting process last year that some justices appeared to support partisan interests of legislators and state office holders. To what extent does or should the court defer to legislators or state leaders? This is kind of a sticky wicket, and I don't know if you're going to be able to respond, but if you're game for that.
Can I say we should never defer to any individual? Our deference is strictly to how we should interpret the law. I mean, for people to say, you know, some people campaign to say you need to elect, you know, X because we need to protect what our wonderful governor and our General Assembly does. That's not our job to protect what they do. Our job is to determine if there's a challenge to anything they've done, whether it is lawful and constitutional, period. So it's not to any individual, it's not to any group, it's to the analysis of, it's to the challenge, because we can't even bring our own cases. If someone challenges something as unlawful or constitutional, particularly since we have the final say on the Constitution, that's where our role comes in. But it doesn't matter who did it or why.
Yes.
Thank you very much. And I think that Justice Donnelly, I think maybe you have something to add to that.
Yeah, I mean, I think we have a record of standing up when the legislature produces something that we consider constitutional. We have a system of checks and balances. That's how our system was designed. They are checks on us. We should be checks on them. In the Youngstown school case, the Constitution says that a bill has to have 3 public readings. And in that particular case, they totally, at the 3rd reading, without telling anybody, put in a brand new, what was a 11-page bill or something like that, to a 97-page bill, taking over the Youngstown schools. Justice Stewart dissented. I dissented. I said it was a travesty of justice. Chief Justice Kennedy, who wrote the majority, who said the legislature can do that, said the only check on them is their oath of office that they take when they're elected to the legislature, and the public can vote them out. That's what she thinks is an effective check. I don't. I think that we have a responsibility to follow the law and enforce the law when they produce something unconstitutional. And remember what they did in 2023 when Alito said this is a state matter, and they took away a right that existed for 50 years. Okay, what did Alito say in his opinion? He said women are not without electoral power, and he thinks he lives in a bubble because he thinks everybody thinks like him about this particular issue. And then Kansas proved him wrong, and then Ohio proved him wrong. And look at what they did, that legislature, that supermajority, to try to prevent your voice from being heard. They held an illegal election in August of 2023. I wrote the dissent on that. And now on the books, thanks to our 4 Republican colleagues, is precedent that says the legislature is allowed to break their own laws. That's what they do.
Someone asked 2 questions quickly, Debbie, about do we have a code of ethics? Yes, all judges in the state of Ohio, trial court, appellate, and Supreme Court, we have a code of judicial conduct that governs not only our conduct, but it governs the conduct of judicial candidates. And so I think we have a great code. We have disciplinary counsel and board of professional conduct that enforces it when complaints are filed, and final decisions with regard to disciplinary action of lawyers and judges is in the hands of the Supreme Court based on how we've treated people. And the goal is not so much to punish those who violate that code, but it is to protect the public and to steer confidence. And I think we have a great code that the Supreme Court of the United States could probably use a little bit of, because the things that have come out of that court, I was appalled that no such code even exists for them. You know, we can't even take gifts over $75 without reporting them, and so we're really bound by a good code of ethics, I think.
Thank you. Judge Forbes, do you have anything to add to that?
I'm going to have to confess I lost the thread of the question.
Oh, yeah, sorry about that. Well, we were talking about the undue influence from the legislators or state leaders, particularly when we're in a state that's gerrymandered.
Oh, right.
The total control is Republican, and so there's a question of whether there should be whether there is undue influence exerted from state leaders or legislators.
Yeah, I'm going to have to agree with Justices Stewart and Donnelly that no, I mean, we do not have to defer to any individuals about anything. And one of the things I just would like to note is that we have a social contract in this country that says that when the judiciary says something is unconstitutional, then it is. And it's up to the legislature then to revisit whatever was the legislative proposal that was found to be unconstitutional. If they would like to try to revamp it, revise it so that it can satisfy the dictates of the Constitution. When legislators disagree with the judiciary about whether something is constitutional or unconstitutional, great. They can tell their friends that at a cocktail party, but it has no legal effect. When the Supreme Court mandates are not followed by legislators, they are violating their oath. And I agree wholeheartedly that they should be voted out of office, because that is breaking faith with our entire system of governance and the oath that they took before when they took office.
I think we've been knowing of dealing with the Vouchers Hurt Ohio lawsuit that's going to be coming up, and I know you can't speak to that directly, but we know that the legislature ignored Supreme Court mandate for years and years, and appears to be getting ready to do so again. So I guess a question related is how is there any ability of court decisions to be actually followed by the legislature, or is it just, well, they can ignore it and that's the way it goes?
I think the power rests in the hands of the people. They need to understand that under those circumstances, the entire system of governance is based on these checks and balances. And if they are not being adhered to, people should be voted out.
Thank you very much. Is there any last word that anybody would like to say before we close? And again, I want to thank all three of you. It's been very informative and really wonderful. Yeah, big claps. Anybody have a last word before we go?
Just want to thank everybody for their attention today and concern and great questions and great discussion. You know, we're traveling all over the state. We're trying to make as many counties as we possibly can, but I really enjoy these virtual events because we can get more people on, and we could speak as long as we did today. And so if there's other opportunities in the next 2 months where you'd like to invite us, we're more than willing to do that. And
Wonderful.
Thank you, everybody. And if you like what you heard today, please follow us on social media and spread the word any way you can. Postcards, that the rule of law is on the ballot. Your rights are on the ballot this time, and you're looking at 3 judges who are committed to following their oaths and protecting your rights.
Thank you. That just reminds me, I know that some of our members have been having a little bit of trouble getting some literature to go canvassing. There seemed to be a little bit of a holdup. So if there's any way that the 3 of you can move that process along so that we have literature in the hands of the people who are doing canvassing, and also postcards. A lot of us are good postcard writers, so we are very willing to help in these ways. That maybe get together and let us know how we can best get the materials so that we can help spread that word. We'd love to do that. So.
Yeah, I mean, I think we all have websites. If you would like to go into our websites, is it helpful if we put them in the chat, or you probably already have them and can do that?
We will put all the campaign websites in the follow-up with the recording, and we'll be urging people to donate and to become active. I was just wondering about the lit. I know that there's been some out there, but some
Yeah,
people
the
aren't
the
getting
new
it.
batch was ordered. Yeah.
Oh,
Yeah,
yeah,
I
and it's
think
supposed to be delivered tomorrow, actually, so.
Okay. Okay, good. Does that the same go for signs? Do you have signage?
Signs, there are signs are in next week, I think.
Okay. Okay, good to know. Well, we'll try to compile as much information as we can, and if you're willing, we may really take you up and having you come back before the election. So that would be fantastic.
Absolutely. Let us know.
Okay.
Definitely.
Thank you
Fantastic.
so much. Okay.
Bye-bye. Have a good
Everybody
day,
have-
everyone.
Thank
Okay,
you
have
all.
a great day. Okay, thank you.
Hey, Debbie,
Yes.
how do we get on your list to get the recording